All right. Good morning. We're back. Senate Judiciary. We're taking up S-140. Eric Fitzpatrick. We went through this bill last week, well, the week before last, the last legislative week. And because Senator Baruth was absent and because it's a bill that's very important to him, we decided to hold off the vote until today. But because it's over a week old, and some of us are older, our memories may not be all that great. You want to briefly walk us through the bill, Eric, as it stands today?
Yeah, sure. Happy to, Senator Sears. Good morning, everyone. This is Eric Fitzpatrick with the Office of Legislative Counsel, here to chat with the committee about Senate Bill 140, which is an act relating to prohibiting civil arrest at courthouses. No, Senator Sears, did you want to look at the language, share the screen, or just give a quick walkthrough, whatever you prefer?
Yeah, a quick walkthrough would be good.
Yeah, sure. Everyone remembers, I'm sure, although it's been a while because of the break, but the discussion in general about the bill, as I mentioned, it really reflects what the title is. It prohibits civil arrests at courthouses. So in other words, this does not relate to criminal arrests or arrest pursuant to a court order or to a warrant or any sort of arrest that's related to a criminal proceeding. It's only related to an arrest of a person for purposes of securing their appearance at a civil proceeding. Now, you may remember it was an interesting historical discussion around this prohibition. It actually has its roots in English common law, which was then brought over to the United States, and there existed in common law this privilege. It was a privilege against arresting a person at a courthouse or in the neighborhood of a courthouse for purposes of getting them to appear at a civil proceeding. And one might think, well, what are those civil proceedings that for a person that would be arrested for? Isn't arrest generally a criminal term? And these days, that's certainly true. But for a long period of time, historically, a civil arrest was how someone's presence was secured for purposes of when they were being sued civilly. There could be a civil arrest for that. Now, that doesn't happen so much anymore, or really at all, because now when someone is sued civilly, we have the service of process. They are served with a complaint, usually by the sheriff or some other person who's authorized to serve process. But civil arrests can still happen with respect to immigration proceedings, which are civil proceedings. Federal immigration proceedings are civil in nature. So a person, and as you heard in the evidence that the committee heard, it has happened in Vermont as well as in other places, that a person is arrested by federal immigration proceedings, officials, in order to secure that person's appearance at a civil proceeding, a civil immigration proceeding. So what this bill does is it prohibits those arrests in courthouses, in and around courthouse buildings. And that essentially just codifies this common law privilege that has existed, as I said, for many centuries. It existed well back in English common law centuries ago. And there was an interesting, the committee talked about the Southern District of New York federal case, which I explained to the committee before the break, which also reached the conclusion that that common law privilege carries over and continues to exist today. It was adopted when the common law was adopted in this country. And that conclusion is also reflected in this bill, in the sense that the bill codifies that privilege the same way that the Southern District of New York concluded that it was codified in common law, based as well on statutes that have passed in New York and Colorado that have also done something very, very similar to prohibit civil arrests at courthouses. And the language is sort of a combination of the language that it passed in those two statutes as well as the common law privilege itself.
Eric, that was Colorado, and which other state?
New York.
New York. Okay.
Yeah. So the bill contains an additional piece. You remember, there's the prohibition itself. So it says, all right, any person or a family or household member of the person. So you've got two groups of people who can't be arrested at courthouses. not just a person who was attending a court proceeding in good faith as a party, juror, attorney, or witness, but a family or household member of the person who was attending the court proceeding. That's who's covered by the bill. And they are privileged from civil arrest while traveling to, entering, remaining at, or returning from the court proceeding. So if they're attending the proceeding or going to or from it, then they can't be arrested. No, it can't be, subject to civil arrest. There are some exceptions, as I mentioned earlier, for judicially issued warrants, court orders, arrest of contempt of court where the proceeding is occurring, arrest to maintain order or safety in the court where it's occurring. But that's the general way that the prohibition works. The second piece of the bill, you remember, is the remedies piece. And that involves, well, what if it does happen? What are a person's remedies if someone is arrested in violation of this prohibition? And one of the main pieces of that is that the person who conducts the arrest can be subject to civil contempt proceedings, or they could be sued civilly. They could be sued for damages. And one sort of language change that I want to point out here is that, and I'm going to find the right place to put it, or sorry, the right place to mention this. I'm just going to, if you, Senator Sears, maybe I'll just pull up the language just for a moment here. So
Yeah, why don't you? Yeah.
Yeah.
That'd probably
so
be easier for all of us.
Well, plus we can see the proposed change between this version and the previous one. There's a couple of words inserted, which I'll point out to you here. All right. So this prohibition, this piece is what I've already discussed, which is the prohibition on civil
Yeah, we
arrest
can't
generally.
see your screen yet, Eric.
Oh, you can't?
No.
Let's try that again.
There you go.
All right, thank you. So is the language visible now?
Yeah.
Yes.
Great. So yes, we already talked about this part. This is this general prohibition that I just mentioned and the exceptions as well. And moving on to the remedies, you'll see the new language, the new wording, just a couple of new words are on line 20 here. And this has to do with when someone can either be sued or subject to civil contempt proceedings. And you see the new words are knowingly and willfully. So previously it had read, a person who violates this section by executing or assisting with the arrest could be subject to civil contempt or liable for civil false imprisonment action. And you may recall that the committee discussed and was concerned about the possibility that, for example, a Department of Public Safety or Department of Corrections officer who assisted with an arrest, that's line 21, without necessarily intending or even knowing that the arrest was for purposes of having someone appear in a civil proceeding, an immigration proceeding, or something of that nature, could nevertheless be sued or subject to contempt because of the language assisting with. So what was added here is knowingly and willfully, and those actually also are terms that are used in the New York and Colorado statutes that I mentioned. New York uses willfully and Colorado uses knowingly. And so I think the committee figured, just to be doubly safe in this particular type of situation, added both words so that a person couldn't be subject to lawsuit or subject to civil contempt if they, without knowing that the person was being arrested for an immigration proceeding, or without intending to do that, then they wouldn't be able to be sued. And that's the idea behind adding that language. Again, subdivision 2, very similar to what we just described, that the person could be subject to civil actions for damages. This is sort of a general procedural piece about that a person could be a defendant in a civil lawsuit, as we just mentioned, if they are arrested in violation of subsection A. There's the ability of the Attorney General to bring a civil action for appropriate injunctive, equitable, or declaratory relief. In other words, an injunctive injunction they could seek, or a declaratory judgment that could be sought that a particular practice would not be permitted anymore, that these arrests should stop. And that's available if the AG has a reasonable cause to believe that a violation has occurred or will occur.
Eric,
Yep, sorry. Yep.
could you go back up to lines 4 and 5?
Yep.
So if we've changed it to knowingly and willfully, on line 5, it says punitive damages in the case of a willful violation, but haven't we made it so that all violations would be willful?
Yeah, that's an interesting point. The willful violation language is typical that's used in connection with punitive damages. So that's sort of boilerplate for when punitive damages are made available by statute. So in other words, punitive damages not generally available for just a violation. It must be something more than that. So that, I think you're probably correct, Senator Baruch, that because of the definition, the adding of the two terms above, that the violation of subsection A, although I suppose it's possible.
Well, where I'm going with this is, I obviously I wasn't here for the discussion to add knowingly and willfully. Am I correct that Colorado and New York each only had one of those words?
Yes.
So I'm wondering, and I again, I wasn't here for the committee's deliberation on it, but do we need and willfully? If we say knowingly on line 20 of page 1, and then it seems to me the language on page 2 about willful creates a distinction where anything knowingly would be a violation, but then knowingly and willful below would indicate a different set of circumstances that might allow you punitive damages. In other words, I think the problem goes away if you get rid of and willfully on line 20 of page 1 and make it just knowingly.
I think, Philip, if I recall correctly, there was a distinction between having knowledge that this individual is being arrested in violation of this statute and willfully doing the arrest or helping with the arrest anyway, that both of those components were important in what we were intending to achieve. So I would actually see it backwards, that punitive damages should be awarded in the case of a willful and knowing violation, or knowingly, whichever order that was in.
Yeah, I guess that's what I'm saying, Joe, is so if you look at the line 20, can you go up just a little, Eric? Yeah. A person who violates the section by knowingly executing, so they had the knowledge and then they executed anyway or assisted anyway. To me, that's the action that they've taken. So you don't need to try to determine whether they willfully did it because they knowingly did it. So willful to me doesn't serve a real function there except to confuse what we've got on page 2 for punitive damages. Because that line on page 2 seems to suggest that there are violations that would not be willful. And the way it stands now is that's the only violation you could have.
I recall that each of the states that have this now had either willful or knowingly. And we were
Yeah,
trying
and
to cover all bases. So
Right,
in the case of punitive damages, it would make sense to tie both of those words in there, but I don't know that you want to.
It is. So if you get rid of and willfully on line 20, then the violation would be knowingly, and then willful on page 2 would appear for punitive damages.
I wish I could remember the the conversation. It had to do with it came from the Roger Marcoux and the Department of Corrections, I think.
Yeah.
Which is
It
why
was
we decided to put
the
both.
current it was a concern. You have a deputy sheriff doing courthouse security in a probate court, for example, and a person is called in or doing something in the probate court, and then the sheriff is told, ends up because ICE came in and participates, but had no idea that was what was going on.
But wouldn't that be taken care of by knowingly?
I would think so.
So my suggestion would be to eliminate and willfully, and I don't think we lose anything except the potential confusion with that section on page 2.
Okay. I think I'm unless somebody convinces me otherwise, it's here on this bill. I'm okay with that.
I just want to make sure that the DOC and the sheriffs that somehow this doesn't, I can't remember why we did that.
Well,
I
I think
can't,
just being doubly cautious because one state had knowingly and
Yeah.
another state had willingly.
yeah,
Because
And you could certainly,
Yeah, go-
for consistency purposes, either way, you could certainly add knowingly to the punitive damages piece if you're looking
Yeah, why don't-
for consistency. So either way
But-
works.
why don't we put knowingly and willfully in both places?
Fine with me.
well, well, if you, it's still the same problem though, because you're saying punitive damages in the case of a willful violation. If you make it knowing and willful, it still seems to me to imply that there are cases that aren't knowing and willful. And the section makes it clear that those are the only violations that, so
You might also, just to suggest another option, I see your point, Senator Bruce. You don't, since in this particular case, in contrast to most other statutes, as you point out, a violation, this remedy is only available for a knowing and willful violation. You don't need that language really in line 5 for punitive damages at all, because, to avoid the confusion, you could just say punitive damages, semicolon.
yeah,
Because
I think
Okay.
that would be better.
That works.
Okay, you picked a winner, Eric.
once in a while.
So is there a motion? Is there anything else on the bill?
Taking that out
Any
now,
concern?
taking out.
Yeah.
Senator Baruch,
I would move that we amend, or are we,
would be approving draft 3.1 or 2.2. I'm not sure how Eric will do
yeah.
it.
Yeah,
What he,
3.1, that's right.
what he said.
Okay, so Senator Baruch has moved that we approve the amendment to S 140 as seen in draft 3.1, which is a minor technical change of taking out the word willful violation out of on page 2. Any further discussion?
Should I pull the
Hear it.
screen down, Senator Sears? Would you?
Yeah, please do.
Yeah.
Yeah, thank you. We've got a number of. So Peggy, if you would please call the roll.
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes,
Senator Baruch,
Yes,
Senator Sears.
Whoop.
Senator Sears.
I think he's frozen.
Uh-oh.
Oh, God.
There we go.
Yes.
Senator Sears. Yes.
Yes.
Okay. Got it.
Comcast just came and put a whole new line into my house, and it's still unstable. All right.
Right.
Senator, so is there a motion to report favorably as amended S-140?
Yes.
Senator Bruce has moved to report favorably S-140 as amended. Any further discussion? Hearing none, all up. Peggy, would you please call the roll?
Senator Benning.
Yes.
Senator Nika. Yes. Senator White.
Oh,
Yes.
Senator White.
There you go.
Yes, yes,
Senator Baru.
Yes.
Senator Sears.
Yes. Did you get that?
I did.
Okay. All right. Thank you, Eric, very much. Appreciate it. We'll see you tomorrow around 10:30.
Yes.
Who's a reporter?
Senator
Who's the
Baruch
report?
volunteered to report it.
All right.
This is Bill.
And Eric, you'll send it to me after it goes through editing?
Yes, will do.
Eric, if we were to see you around 10:15, would that work?
Tomorrow, you mean?
Yeah.
Yeah, sure, that's fine.
All right. And since Ben is here on S-127 today and would be here tomorrow on S-127, Peggy, why don't we flip and do 127 at 9 a.m. till 10, take our break at 10 to 10:15 at 10, and then at 10:15, take up S-178, and then I think it's going to take a little more time. And then if we have time at 11:15, we'd put in S-254. I
Okay.
suspect 178 may take a little longer than I had originally scheduled it for.
Okay, can you just
Okay.
repeat that? Can you repeat that, Senator Sears? Sorry.
Yes, at 9 a.m., we'd take up S-127.
Okay,
And at 10 o'clock, we'd take a break. And at 10:15, we would take up S-178, the supermajority verdicts, the civil trials.
okay,
And then I would suspect that that's going to take a little bit longer. And so I would schedule 254 at around 11:15, but that might be ambitious.
okay, got it.
how did it get to be crossover week already? I
I don't know,
don't get it.
just the speed with which we work. We've done amazing work this session.
Senator
if you
Sears,
look
your
at the-
problem with Comcast, I don't know if I told this story yet. We've been at my house, our landline has been receiving crank calls forever. And about a month and a half ago, it stopped. We usually get 4 or 5 a day, and it just stopped completely. And one of us, all of a sudden decided we were gonna use the landline instead of our cell phone. We picked it up, there was no dial tone. So that's the way you get rid of spam calls.
Oh, that's a good news. Yeah, there's no dial tone. It's hard for them to spam you. It's been a fascinating journey with Comcast. The guy was here all day for a couple of hours a week ago Sunday trying to fix it. Okay.
All right, well, we'll see you tomorrow.
See you tomorrow,
Bye.
Eric. Thank you.
Yeah.
And now we'll
Yeah.
move on to S-127, which is a strike all of a bill that we're not going to do because we already did it. I mean, we already did the pilot project. And we're really talking about a problem with furlough intercepts. So, Ben, did we walk through this bill already or did it?
Yes, Senator, there's Ben Ogroski for the Office of Legislative Counsel. We did do a walkthrough before the town meeting week break.
Yep.
And there is a new version 2.1, but that just removed the pilot project portion to accurately reflect the status of the law. Otherwise, there have been no changes outside of that.
Okay. So our first, we'll go right to the witnesses, and it is Nicholas Demmel, Commissioner, Department of Corrections. Thank you for being with us.
Good morning. Thank you
Morning.
for the opportunity. I'm glad to be back here. Again, for the record, it's Nick Demmel, Commissioner of the Vermont Department of Corrections. And like I said, I appreciate the opportunity to testify on 127 and our proposal to adjust some of the Rule 24 furlough interruption language. Since we last testified, I had the opportunity to meet with the Defender General, discuss some of our views on the legislation with the goal to make sure that all parties were collaborating in good faith and make sure that everybody felt involved in the process. And I know there were some feelings that that wasn't the case last time, so I wanted to make sure that we addressed that. On some of the areas related to Rule 74 furlough interruptions, we agree. I think venue is the best example of that. And on some of these areas, we disagree. And that one example of that is the standard that the court should use to evaluate these cases. At the end of the day, this is a highly complicated topic, and I think reasonable people can disagree on the best path forward. But I just wanted to note before going further on the Rule 74 piece that I really value my friendship with the Defender General, and I appreciate his collaborative and collegial approach. So I've been glad to have him as a partner on our criminal justice work and look forward to that continued friendship, and hopefully there were no hard feelings about our last testimony. It certainly was not the intention. And I wanted to just say that in this forum and on the record so that everybody could hear that. Regarding Rule 74, though, and S127, the language that we proposed to change Rule 74 and that we asked this committee to consider, I think requests really three substantive adjustments to the law. First, that the language incorporates a certification requirement and an appeal option for the Attorney General's office. Second, that it clarifies the standard that the court should use in reviewing Rule 74 interruptions that meet the criteria of this law. And third, it expands the venue options for incarcerated individuals for their benefit and for the benefit of the court so that the workload is spread across the state at the appropriate venues. These three proposed changes target, I think, three critical pain points that we've identified in the Rule 74 appeals process since its enactment in January of 2021. Those pain points are the administrative burden on the Department of Corrections and on the Attorney General's office in responding to Rule 74 appeals that don't even meet the basic criteria of the law, the confusion and disparity of judicial opinions as they try to interpret the law as it's currently written, and in practice, they're applying inconsistent standards on Rule 74 appeals. And then third, we're overburdening one judicial district, and a simple solution would be to spread that throughout the state's judicial jurisdictions. I think without these changes, the department will continue to suffer from an immense administrative burden. And I can't underscore that enough. And I'd be happy to talk more about what that burden looks like, but it is really taxing our resources. It distracts from critical work that we're trying to do. I'll share with you, the department does not have a Rule 74 clerk. Instead, we've had to reassign our corrections legal services director to take on those responsibilities. And that's detracting for her ability to do her normally assigned duties. Additionally, I think that without these changes, the judiciary will continue to hand down inconsistent decisions based on disparate interpretations of what standard is outlined in the statute. So to that end, the department provided the committee, the Defender General, and the judiciary this morning with some information that we'd like to discuss today. And if we can, I'd like to have Dale put it up on the screen for your consideration. And I'd be happy to walk you through just a few slides that try to capture the problem set that the department is facing.
Okay, please go ahead, Dale.
So as soon as we get it loaded up here, we can start. I think it takes a minute to cycle to everybody's computers.
So screen sharing is paused.
Oh, we might need some assistance on that.
So
Oh, don't ask me.
double click to enter.
Peggy's looking into it.
Okay,
There we go.
it's on my screen. Does everybody else see the
Yeah,
title
we
slide here?
can see it now. Yeah.
Okay.
Is this going to be on our webpage?
It is on the webpage.
Okay, thank you.
And just to reiterate, I also shared this with the Defender General and with the Judiciary, Judge Zone this morning, so that they had it at the same time we provided it to the committee.
Okay.
So we can go to slide 2 here, Dale, if you can help me. So what this slide captures is oops, sorry, I've lost my screen share here. Captures a quotation by the one of the courts in Vermont while they were reviewing a Rule 74 appeal. And there's 2 quotes here. I'll let you read the first quote at your leisure, but on the second quote, I think this really encapsulates the problem the courts and the department is facing as it relates to the standard. And so I'll read the second quote for you. The puzzle is how this court can determine that the agency abused its discretion if the court first considers information presented now that was not presented to an agency, and or second, makes a de novo determination rather than reviewing the agency's decision under abuse of discretion standard of review. The answer is that it cannot do so. The statute is inherently inconsistent. And the issue that the judge is talking about in this opinion is the fact that there is an de novo review outlined in the statute, but also a discussion of the abuse of discretion. And so the court is supposed to use the de novo standard to determine if the department abused its discretion in making its decision. And what the court is saying is those 2 standards cannot coexist. What our language does in the bill is try to adjust that and remove the de novo language and instead use the traditional abuse of discretion standard, which we think best applies here. And we're trying to avoid this problem set, but I thought it was worth highlighting that this is what the judiciary is struggling with as it tries to understand the statute as it's written and apply it to our appeals. So on the next slide, if we can move to the next one, Dale.
It's not moving.
There we go. What we wanted to highlight for you is over the last several years, over the last 5 years, I believe this slide depicts, the number of furloughs that we've returned to custody. I want to caveat this slide in part because the first 3 bars that you'll see is data that was provided by CSG, who's here to testify today. And those 3 bars do capture work crew returns. So folks who violated work crew rules and were returned to custody. Those are not counted in the last 2 bars. But what's worth noting here is that the work crew returns are not eligible for furlough interrupt review under Rule 74 anyway. So I just wanted to caveat that, and it's not terribly material, but I wanted to make sure that we were being transparent with the data here. What you'll see though over time, and 2001 being the time that the Rule 74 legislation took effect, but also the time that the department changed its policy and began using the grid that was developed in concert with CSG to review our furlough interrupt decisions. And you'll see that there is a precipitous decline in the individuals who are being returned to custody over the last year and change, so 2021 and 2022. I also wanted to highlight this note. So if you look at 2022, you'll see that there are 18 furlough returns to custody so far this year. Despite all of the intervention strategies that this department has applied to these 18 individuals, since they first came in contact with the Department of Corrections, these individuals have been convicted of 164 new criminal convictions. 18 individuals represent 164 convictions. Those are not new charges, those are convictions. What this highlights is that the individuals the department is in fact returning to custody are the individuals who are unwilling or unable to participate in the standards that are set out for them when they are on release. These are not individuals who are being interrupted because they don't make a phone call to their parole officer. These are individuals who are being interrupted because they are repeatedly committing new crimes or failing to comply with the rules that the state has determined are appropriate to let them out in our communities. So on this slide, we see a couple of additional graphs that highlight our furlough returns by reason. What you'll see on the left-hand side is the totality of the different bars. So the reasons that they were returned are either for new crimes and an absconsion, technical only, or technical and an absconsion. If we couple on the right-hand side the 3 new crime categories, they represent 82% of our furlough returns between 2021 and 2022. What that means is that the department is 82% of the time returning people only because they have a new crime or a technical violation. I'm sorry, a technical or absconding violation. For the remaining cases, those individuals, that last bar, are the folks who are being returned on technical only violations. And we can talk about that in just a moment. And then I just wanted to highlight on the next slide, and Dale's getting ahead of me here, thanks. This pie chart represents the totality of Rule 74 cases that have been filed since this law took effect. In 78% of those cases, the department's position was affirmed, meaning the decision that the department imposed on the furlough interrupt was affirmed by the court. In the cases in which there was a split or a stipulation was 13%, and the number of reversed cases was 8%. What that means in total numbers, though, is only 6 cases were reversed. So for 78% of cases, we are filing a robust amount of information and taking on that administrative burden and are being successful, which we appreciate, but comes with a huge burden for the department. And so I think what this depicts is that we're not capriciously returning people to custody because of furlough interruptions, but instead following the rules that are laid out by this body in statute, and following the rules in our own policy, which we carefully crafted with CSG to match the intention of this body's legislation. We do have a couple of additional slides that we included here. We don't have to walk through them, but I wanted you to have them for your reference, and that's the department's policy on furlough violations, the grid itself, which has been a topic of much discussion in this body. And then I'll turn it over to Dale to discuss, I think, the last slide, and it could be a nice segue to another witness who's with us today.
Yeah, thank you, Commissioner. For the record, my name is Dale Crook. I'm the Director of Field Services for the Vermont Department of Corrections. This slide here is our sanctioning grid that has been brought up previously. I just want to name 2 things of note that while someone may be held on an interrupt, they are still eligible for their parole review. So that does not limit them from having the opportunity to earn parole if the parole board chooses to place an individual on parole. In addition, in order to get a second and third significant violation, what that means is the individual that we're supervising has failed to make it 1 year in the community without picking up a significant violation. Individuals that have made it 1 year in the community under supervision without picking up a significant violation, which was on the previous screen, their next significant violation would be reset to 1. So we're really trying to take into account stability to match the rest of the individuals that we're supervising. And on this screen, this is part of the justice reinvestment. We revamped our violation and response grid because we removed all of our short-term incarcerated sanctions, graduated sanctions. So there are no sanctions really applied to the department under 90 days. Everything is over 90 days as far as interrupts are concerned. And as you can see by this chart, it is a progressive chart. So an individual that, for example, fails to report or doesn't make contact with their PO for one time, like our response in the level 1 grid on the top right is generally a thanking, an apology to get them to understand their problem, or we do some cost benefit analysis with them. As behaviors continue to occur, or if the violation increases, as you can see, we move down, and as we start moving down to our responses, that's where we start applying more and more restrictive responses. They're still all in the community. There is no incarcerated responses on this grid. So as you can see, this is a progressive grid. And as you move down, you have to have multiple violating behaviors or a more severe or serious infraction in order to get a higher level of response. And that is it for the chart. I want to try to, there, stop sharing.
Okay. Any questions for the commissioner, for Dale Crook, head of the field services? Can you give us some examples of the behavior where the courts have not backed you?
Yes, actually with me, I have Gary Marble. I can put my camera out here so you can come over and see. He is one of the individuals that manages our case staffing process. So out of the 6 cases that we have been reversed on, 5 were around absconding and definitions, interpretations of absconding, which as the committee remembers, about 3 years ago, the absconding was considered an escape and was a felony charge. And at the request of the department, we made a request to the legislators to have it decriminalized. And then most recently, it altered again to additional language around the intent of the individual to avoid supervision is now a criminal charge. So it has fluctuated a little bit. The 6th case, the other case, involved contact as a sex offender with a contact offense and some domestic type behaviors of intimidation, and including, I believe this is the case of individual poured gas on the partner or the girlfriend's vehicle. So we thought that was concerning behavior and we responded to appropriately. The committee should understand that when these cases get reversed, we end up releasing them. And these are individuals that we've kind of believe had issues and concerns supervising previously. And now we're releasing them with 0 reentry or preparatory work. They were released either immediately. So whatever residence or proposed plan they have, good, bad, or indifferent is what occurs when the reversal occurs.
Well, I'm not clear on the release. So you just added a new element. What does that mean? You no longer supervise them?
No, so we have an individual, and Rule 74 indicates that the department was abused its discretion, and we are ordered to release the offender back into the community. So we release the offender back in the community with no reentry or preparatory planning for that release. So the individual is just basically, we kind of really just open their door, release them, and they continue back under supervision.
Okay, thank you. I was a little confused with that. Gary, do you have anything to add about who are the? My mother used to say, "Who are these people? Who's getting interrupted, and how and when the court is either that can."
Oh, I think he froze.
A little to that and the impact of that.
Oh, Senator, I think you froze for your question.
Oh, great. All right. Am I back?
Yes, you're back, sir.
Okay. My question has to do with the commissioner said there's three problems. One's administrative burden, understood. One is the one court burden. But the second one that I need to better understand is the confusion and inconsistent decisions. And can you help us with some examples of that? And hopefully I won't waste between now and the time you finish.
Go ahead, Gary. Can you hear me on Director Crook's mic?
Yes.
Yeah.
Okay, great. Thank you, Senator Sears. My name is Gary Marvel. I'm the Field Operations Manager for the Department of Corrections. And I oversee the case staffings for the furlough interrupts. So in terms of the decisions from the court, a lot of the decisions that we're receiving where they don't agree with us is more around the time of the interrupt rather than the criteria under which our discretion was abused, which is set by the statute. So that's where we run into some discrepancy on what's deemed to be appropriate by the court versus what the department feels is appropriate for in correlation to the behavior. Could you give me a little bit more clarity about what you're asking? I just want to make sure I'm answering.
Well, I've never been to court with somebody whose furlough's been interrupted, and they're claiming that it was unfair that their furlough was uninterrupted. And I was looking for some examples, specific examples of the type of behavior, and the court has created confusion and inconsistent decisions. That was the statement from the commissioner. And I'd just like to hear some examples. You know,
Sure.
The guy went out, slapped his girlfriend, we put him back in, and the judge said that wasn't enough and put him back out. That's what I'm looking for.
Sure, yeah, so as your Director Crook and the commissioner already covered, about 82% are for absconding or new crimes, but of the technical violations that we're receiving, which are ones where just a new crime didn't get charged, the behaviors across the board, but they're predominantly risk-related behavior. So I just actually reviewed all of the cases we had over the last 15 months, and many of these were cases that would or could be criminally charged, but they weren't for whatever reason, sometimes victim cooperation or any number of legal reasons why it didn't occur. But the behaviors, the most frequent one that I saw was sexual offenders with contact with minors or getting terminated from treatment or not telling us where they live. Another common one is violence. We had several very concerning cases that were strictly technical violations, but there were no charges brought, so they remained technical. But there was a physical altercation with another individual, most commonly interpersonal violence. And those are the types of behaviors we generally return people for.
I'm trying to understand the statement, and maybe I'm thick, which is debatable. It's confusion and inconsistent decisions. Can you give me examples of where there's confusion on, maybe it's the probation officer who recommends a furlough be interrupted, and that this individual is put back in, and then there's a court case, and what the commissioner said, there's confusion and inconsistent decisions. I would really like an example. John Jones, inconsistent decision or something of that nature. I'm trying to understand the behaviors that are resulting in these decisions, because it should be pretty obvious if I go out and commit 5 new crimes, that maybe it's time to have my furlough interrupted.
Sorry.
And yeah, that's what I'm trying to understand. Is it these types of cases, or is it real, is absconding,
All right, sir. I think I understand what you're looking for. So one case we had the individual, we were not able to locate him to provide supervision. He was ended up picked up after we filed a warrant in New Hampshire. So he left the state, he was on furlough, and the court indicated that we did not abuse our discretion in the return. They just didn't like our decision on the length. So it wasn't that we abused our discretion for incarcerating, giving an interrupt. The court and it had his determination that he didn't like our determination and changed it. So that's an example.
I don't want to, we're going to come back to this tomorrow morning, but I don't want to, I know David Diamora is here from Connecticut, and he may not be available tomorrow. And if he wants to provide a few comments in the last 6 or 7 minutes, would be appreciated. And we can talk tomorrow with all of you. I don't know if what David's schedule's like. So looks like he's traveling. David, good to see you as always.
Good morning, Senator. For the record, David Demora, Senior Advisor at the Council of State Governments Justice Center. And I apologize if you hear my dogs barking in the background. They decided to start barking just at the moment that you asked me to speak. I am happy to make a few comments. I'm certainly not here to talk about the bill one way or the other, but I just wanted to give folks some background in terms of justice reinvestment. This will be a revision or a repeat for some of you who have already heard this, and for others, it may be some additional information. But as you all know, justice reinvestment focuses on keeping the right people incarcerated and not having the wrong people unnecessarily incarcerated if they can be managed safely in the community. And the second component of that is that when we look at the issue of community supervision, to try to assure that community supervision is done in an evidence-based manner, that the research that we have currently available is being followed in terms of decisions being made. As part of our work with Vermont over the last several years, a number of things occurred, and you've heard some of them discussed by Dale and others, but let me just briefly go over them as well. One is the issue of the revision of the community supervision standards and the contact standards that the department and the parole board worked on jointly to better align with evidence-based practices. And basically what those practices say is you should limit conditions to those that are relevant to effectively manage someone in the community in a safe way, and to not overload the individual with conditions unrelated to increasing success and to assuring community safety. When you overload people with unnecessary conditions, it increases failure through technical violations that don't improve public safety and in fact impair the effective habilitation for the individual who's under supervision. And we've sort of seen those changes happening in DOC. One has to understand that all systems take a long time to change, whether that's a Department of Correction or that's a legislature or that's a court, or a health system. They all take time. We're talking about moving massive systems. DOC also revised their sanctions grid according to current research-supported practices in order to have these tiers. In other words, to have different levels of responses based on the risk level of the individual. And that's really important because what we see in too many states is that they have just one type of sanctions grid. They respond to everybody with the same kind of response, which usually means they over-respond to low-risk folks, increasing their failure. And bluntly, they under-respond to high-risk folks because they're wasting so much time with the low-risk folks that they can't really do much about in terms of lowering their risk further. So what happens is inadvertently, they decrease public safety over the long run when they don't have responses that are based on the degree of risk that the individual poses. And when I say degree of risk, I mean likelihood of failure and or potential to hurt someone or something in the community. What's important is that short-term revocations have been removed, and I know that there are some questions to be worked out in terms of what is are we making good decisions about the length? How is that working? And I know there are honest disagreements in Vermont about how that's going. That's fine. Vermont will need to work that out. What is important is that generally speaking, short-term revocations have been removed. That limits the disruptions to everyday living, loss of jobs, housing, all of those things that get in the way. We did also indicate that there would need to be the development of an accompanying incentives matrix. While those changes have begun to be made, that policy is still in development, and we certainly would urge that the department continue to move forward on that. Importantly, as part of our ongoing data collection, because we are collecting data for the next year and 3 quarters in terms of what's going on, what we found is that currently 51% of those that are returned receive a period of a year or more, and 31% 2 to 4 years, which suggests that there's a significant level of concern over those people's behaviors. And that's what we would want to see. In other words, we'd want to see interrupts for more serious issues and not for low-level issues. Also, we projected in late fall that if DOC continued with the changes developed, there'd be a significant drop in the interrupts. We were projecting more than a 70% drop, actually. We sort of looked at the numbers ourselves and thought, this can't be. But in fact, that was where it came down to. We looked at that. And the reality is that when we compare it to pre-COVID numbers, because you can't compare it to COVID numbers, obviously, but in 18, there were over 1,400. In FY19, over 1,300. DOC is currently on target to have about 286 interrupts this year or less. And that trends the way that we'd like to see it. We want to utilize incarceration for those that are a threat to public safety and utilize programming, community supervision, and incentives and sanctions for those who are not a threat to public safety. Part of this change came about because of the policy changes that have been mentioned, part by the beginning of a change, a culture change, frankly, within DOC, to bring all the components under the same philosophy, to not have a law and order component, to not have a case management component, to not have a social worker component, but to understand that supervision is a complicated mix of case management, of social work, and of assuring public safety, not law and order, but assuring public safety. As some of you know, part of the phase 2 of JRI, we were able to pass through federal dollars to the state for additional work. The dollars include a significant amount of money for training and for the changes to the information management system to better track outcomes. Fortunately, Vermont was able to receive a no-cost extension to achieve the additional or ongoing training of officers to the culture change that I was just mentioning, as well as the continued development of the information management system. The reason for this was nothing about Vermont in terms of the time that it took. There were changes at the federal level that caused delays in the approval of the money, which resulted in a very short period of time in order to do that. And it wasn't possible to get all these things done in that short period of time. So fortunately, the federal government did allow for this no-cost extension, which will allow Vermont to do the additional training and do the additional development. So from our perspective, while nothing is ever perfect, from our perspective, a lot of the work that we were doing with Vermont and trying to help Vermont do is occurring and is moving forward in the right direction based on what it is that the work that we did with folks. And for the next year and a half, year and 3 quarters, we will be continuing to collect data, looking at these things to see, is it trending in the right direction? And we'll also be keeping an eye on crime issues and new crime, because one of the things that we also want to assure is that as these changes happen, that they're not resulting in an increase in new crime by those individuals who are on supervision. And based on at least the initial data, some of which you saw in the charts, that's not what you're seeing. What you're seeing in terms of the increase in crime in Vermont has a lot to do with things you've heard me talk about before, related specifically to domestic and interpersonal violence, and something that separately from this discussion certainly needs to be focused on as Vermont moves forward looking at these issues. Forgive my extreme speed in doing that, but you mentioned I had 6 minutes. I wanted to try to get that all in.
No, I
I'm more than
did a
happy
great job.
to answer any questions or to say thank you very much.
Well, I thank you, David. And I don't know if there are any other questions, but we're going to pick up here tomorrow morning at 9 a.m. And I still would like some examples. And David, I know that you and I have talked a lot about particularly the prior practice was people who were just paying the neck get interrupted, and people with very serious criminal activity don't. And that was one of the things that Justice Reinvestment 2 tried to address. Do you think that in your initial data, do you think that that's happening?
So I don't have individual case level information, but when I look at the statistics, when I look at the statistics of people, percentage of people a year or more, and the percentage of people 2 to 4 years, and the low percentage of people that are that 90 days or 180 days, it suggests that that is in fact trending in the right direction. Short of literally doing a case review of every single case, I could not tell you that. But statistically, this is what we want to see. We don't want to see, frankly, I don't want to see a lot of people even with 90-day interrupts. I want to see, when I say I want to see longer ones, I don't mean I want people to get longer ones. What I mean is I want people
No,
who
I
are
think we
more
understand.
serious folks to get the longer ones.
Yeah, to start with your initial comment that what we're looking through justice reinvestment too is to make sure that the right people are incarcerated and not the wrong. So I appreciate that, everybody. We're going to break or adjourn for today. Come back here tomorrow at 9 a.m. and pick up on this bill. Hopefully everybody can make that, and we haven't made your